We're recording.
Wonderful. Good morning, everyone, and thank you so much for coming out on your Saturday morning, giving up a Saturday morning, a few hours with us, to be part of a UPR Human Rights Consultation titled Set Up to Suppress, when unfounded criminal charges are used to deter First Amendment activity in America. Now, this event is hosted by the United Nations Association of Atlanta with National Judicial Conduct and Disability Law Project, Inc., and Golden Badge. Now, I'm a UNA member. I'm also Executive Director of National Judicial Conduct and Disability Law Project. We refer to it as the Law Project for short because it's a real tongue twister. And then I'm a co-administrator of Golden Badge. And this Saturday morning, I think everybody who had RSVP'd to come, a lot of them realized that I was connected to all these groups, so they texted me and said they couldn't make it and asked me to carry on, which I will do. But you know, it's very important that we're having this meeting, no matter how many were to attend. Welcome to everyone who's participating by video or phone. We're glad to see you, glad to have you here as well. We're going to, we have our limited technical capacity, so rather than panning the room, what we'll do is we'll have, when people want to address members who are joining us by, our participants who are joining us by video or audio, we'll have them step up to the podium. Again, we're very much glad to have you here, whether you're joining by phone, video, or you're actually here with us physically. This is a very important meeting, and having this having this conversation is very important, and it's very helpful that the United Nations Association is involved. Probably most of you have seen a written description of our community consultation, but for posterity purposes for our video, let me explain. The United States Human Rights Record is going to be reviewed by the United Nations as part of this routine event called the Universal Periodic Review. The United States, because it's a member of the United Nations, their human rights record, our human rights record, is going to be reviewed by as part of this UN process in May of this year, May 2020. All the members of the United Nations, all the member states, nations, their human rights record is reviewed periodically through this process. I think it's either every 4 or 5 years. Do you know, Judge Downey?
No, I'm sorry.
I think it's every 5 years that this happens. And they're basically checking to determine the commitment to human rights of all of its member states. And so what happens is they ask the participating state, the state that's under, the nation that's under review, to give a report, their impression of their human rights record. But they also encourage civil society, NGOs, everyone that's the citizens that are part of this nation are residing, or who have a stake in that country's human rights records to give input as well. So one of the ways that you can provide input is by conducting these community consultations. What will happen is we talk about a certain issue, and then our input is shared with the United Nations. According to the United Nations Association, the United Nations Association, USA, is like a support group for the United Nations here in America. It's trying to have a closer working relationship between the U.S. and the United Nations, and help also American citizens see the relevance of UN operations to our everyday affairs. Now, the UNA explains that the goal of organizing a local meeting such as this is to set the agenda, to help set the agenda on a human rights challenge in the United States collaborate with like-minded people and help catalyze change in the U.S. through a universal UN process. So we're trying to help set the agenda with regard to what we've coined as set up to suppress, when unfounded criminal charges are used to deter First Amendment activity in America. Our topic today involves a wide variety of considerations. I often say there are a lot of moving parts, but what I want to encourage everyone to do is consider this gathering as primarily a focus on the U.S. First Amendment, the rights that it protects, the kind of activities it's supposed to protect, what all that means to us, especially when exercising those rights seem to have consequences. So to get a little bit interactive before we start talking about particular cases, let's just sort of review what rights the First Amendment protects and what your impressions are the kind of activities that the First Amendment protects, are supposed to protect. You want to give it a first shot, Dr. Jackson?
So it protects freedom of speech,
Freedom of speech,
association, expression,
petition.
I think that's pretty much it.
Did you mention press?
Pardon?
Did you mention press?
Press, yes.
Yes, and also freedom of assembly.
Yes.
Okay.
Assembly petition.
Okay. Anybody want to give some examples as to the type of activity that would be protected under the First Amendment, as far as you would think? What about you, Sonny?
Freedom of protest.
Press. Okay, coming together to protest. Lobbying. At one time in our country, there was a big problem depending on who you were associated with, what organizations that you were part of. People would say that you're a communist if you were if your name was linked to certain organizations. What other type of activities is Mrs. Roche? Freedom of speech. Okay. Anything else you want to add, Judge Nally, to give us a better sense of the kind of activities that?
Well, I think everyone is basically familiar with the First Amendment protections. I think the question that really should be addressed is not whether or not those are protected, but whether or not they are in fact protected.
Excellent point. Excellent point.
Zena, may I add one? I don't believe I heard the word assembly, freedom of assembly.
Yes, yes. And we've got an example of coming together to protest rally. That would be something that should be protected by the First Amendment. Well, as we go through specific cases, we're going to get some real life examples, some concrete examples of activities that should be protected under the First Amendment. It's a personal mission of mine to try to help people see that an exercise of First Amendment rights can happen to anyone, okay, or any American at least. Now, that may seem an odd statement to make, but what happens is that a lot of people are under the impression that when the exercise of their First Amendment rights seems to bring negative consequences, that it's just a simple matter of avoiding certain potentially controversial exercises of the First Amendment. And so what I try to emphasize is that you can find yourself engaged in an exercise of First Amendment without having to intend to make waves, okay? You can still find yourself facing complications because of different First Amendment activity. Now, the cases that we're going to feature today involve pretty much generally people who are very conscientious, arguably outspoken, proactive. And part of what I'd like for all of us to consider while we're hearing from the community, members of the community, is what would be the consequences if most Americans avoided, you know, the kind of conduct that these individuals engaged in? And again, we're speaking, and we want to trigger this thought process not only on the part of those who are here in the meeting, but also those who will see this video presentation later. I'd like for you to, I really invite you to go beyond thinking, what would you do, or what wouldn't you do? And to just consider the likely effect if most of us avoided the certain First Amendment activities. Okay, I just think that's just very important, because again, we're going to be hearing some very conscientious people. Some of them are very proactive, outspoken, and it's easy, in my view, for someone to say, "Well, I wouldn't have said that, or I wouldn't have done that." I want us to consider what would you have done if you were in those circumstances. But I also want you to imagine an America where most of us we generally tended to avoid the type of conduct, First Amendment activity that's going to be featured in these cases today. With that, I think it's time for us to hear from all of you. This is a community consultation, it's not a lecture. We'll start with Mr. Britton Mosley Sr. He's joining us by phone. Now, you don't have to pull it out now, but a one-page written description of Mr. Mosley's case is included with your conference material. So, Mr. Scott, if you can go ahead and unmute Mr. Mosley, and we'll hear from him. And I think that, you know, you can be comfortable giving us the details that you need, Mr. Mosley, and I'll give you I'll let you know when you've been speaking for, let's say, 5 minutes. Okay? Go ahead.
You want me to speak now?
Oh, yeah, go ahead.
Oh, good morning. Greetings, everyone. My name is Britton Mosley Sr. In the early 90s, I worked in the correctional system in Mississippi as a correctional officer and also correctional administrator as an assistant chief of security. And during my tour as a correctional officer at South Mississippi Correctional Facility in Leachville, Mississippi, I was outspoken about a lot of abuse of the inmates going on the shift that I worked on. I worked on a midnight shift, so there wasn't a lot of administrators there, and there was some terrible things going on. Inmates was taken out and beaten and abused just on a level that you could never, well, it's Mississippi, so you can't imagine. And I was blown away that some of these tactics was happening in the from 91 to 2001 when I worked in the criminal justice system down there. So when I reported all this, I became a target. You know, they considered me as an inmate lover. And what happened, they recruited inmates to plant drugs on me. And they could only get one guy to participate. And the way they did it, they lured me off the compound on a project. And when I got back, they had planted an attaché case in my office with 2 ounces of marijuana hidden in some baby powder. And this all started out earlier that day when an officer approached me and asked me, how did you get personal hygiene material to an inmate? And I told him you have to clear it with the watch commander. And it's something I knew that the inmate knew and he knew. Red flags went up. So when I got back to my duty station, the sergeant told me that this officer left a package there and he was acting very suspicious that he would search it. Well, this particular officer, he had discussed with me earlier about this inmate worked for him. He didn't work for me. And so why would he leave a package there to give to an inmate that worked for him? So sure enough, when I call another officer over to shake the package down. And this, be mindful now, this inmate was like 6'4", about 290, and weighed about a 14 shoe. And inside of this attaché case was a size 8 shoe, some pink hair moisturizer for a bald inmate, and a size 8 shower shoe. And I took the baby powder and poured it out in a plastic bag, and there was 2 ounces of marijuana wrapped in black tape. Now, the black tape tactic is how we train dogs on the K9 unit. So when the dog hit on the drugs, they couldn't get into the marijuana. So this was Department of Correction marijuana that was being used. And my 2 bosses that worked 8-hour shifts, and I worked 10-hour shifts. And normally, their vehicle be parked right in front of the building. So this was after the time that they got off. So naturally, the vehicles was gone. And so when me and the other officer discovered the marijuana, and when I walked towards the side where they worked, it was a normal day. The door was closed and locked, and the shades was drawn. Evidently, somebody inside went to the bathroom, and I could see a light in there. And inside of there was my 2 bosses hiding to come and bust me with that marijuana. And just luckily, I found it.
Yeah.
And so I requested an investigation.
Mr. Mosley, can I interrupt you for a minute?
Yeah.
We have the basic incidents in your written statement. Fast forward to the second attempt to set you up, because I also want you to have plenty enough time to tell us
right.
about what happened after all of these 2 setups.
Oh, okay. I'll get to that then. I'm sorry. So what I did, I requested a federal investigation. And during the course of the federal investigation, I thought was going on a valid investigation. An inmate came to me and told me that he was offered an early release from prison if he would sit me up. And he told me who the guys were. And so I brought in a tape recorder and put it on the inmate, and he recorded one of the co-conspirators, and sure enough, they was trying to set me up. It was all on tape. And so what I did, I filed a lawsuit against the Department of Correction. And when I went to court, a lot of evidence was withheld. My lawyer and the Department of Correction lawyers and all, they withheld evidence. And during the court proceedings, when I went to federal court, the judge presiding over it, which was Judge Charles Pickering, he had seen and heard the tape and all this before the court proceedings. However, during he got with my lawyer and them was conspired to withhold a lot of evidence. And during the court proceedings, the judge would send, when the inmate got ready to testify, he sent the jury out. He didn't allow the tape, the audio tape to be played. And it's a vast of evidence that they just completely withheld. And so naturally, I lost the case.
Now, Mr. Mosley, can you tell us, before you didn't go straight to litigation, there was also some government investigations of your allegations, is that correct?
Well, when I requested the investigation, the FBI guy that was assigned to the investigation, I found out during the interview with him, I mentioned the investigator for the Department of Correction was one of the co-conspirators, and he got real upset about that because he said this guy wouldn't do anything like that. And I found out later that him and that particular guy was in the Mississippi Highway Patrol together. And when he retired from the Highway Patrol, he became an FBI agent. So the whole investigation was compromised. And I'm an author of 2 books where it details everything that I'm talking about. So it was, and when I requested an investigation from the Justice Department in Washington, I didn't get any results.
tell us a bit about that. I think in your book, and we have a copy of it here, it's literally a blueprint on, you know, what a lot of people say was just whitewash. What Mr. Mosley is unique, as you'll see among the people who speak today, he did get several government-involved investigations. He had internal prison investigation, their investigators. He went to the Department of Justice. I think you had a U.S. attorney involved. But tell us about that report that got produced by the Justice Department.
The report by the government?
Yes, I think it was the Department of Justice that you said it seemed like it was a really, it was lengthy report. It seemed like they had done a thorough investigation.
Oh yeah, well, the FBI that investigated, when he sent his report to the Justice Department in Washington, he said I had unnamed individuals, as if like I just made an allegation against people that I didn't name. And the book clearly showed that I did indeed name the people. And so what I did, I requested an unbreached investigation because a lot of it was redacted. A lot of the investigation was redacted. He only interviewed people that wasn't relevant to the case. All the people that was relevant to the setup, he never interviewed them. And so when the Justice Department got the 301 report from the FBI, it mainly showed that I was just making allegations against people, unnamed people. And that's the way the report was written. And so I went for years trying to get the unredacted, unbreached report, and the Justice Department never gave it to me. And
well, okay, now what we're going to do now is, I think people have gotten a good flavor of your circumstances. We want to give everyone an opportunity to ask you specific questions if they have them before we move on to the next case. And I think we'll have time to flush out any really burning details that people feel they need to have in order to understand what happened in your case. So if there's anybody who's joining us virtually, if you have any questions or comments for Mr. Mosley, and if there's anyone here who has any questions or comments, I ask that you step up to the podium and you can do that. Okay, so if not, we're going to move on to the next case and come back.
Okay, we have a question, Zena, from, let's see, I have to unmute him, hold on.
I got it unmuted.
Oh, you're unmuted, there you go. Question.
Yeah, great. Yeah, thank you. This is Kernan Mannion, Dr. Mannion speaking. And I'm so distressed to hear your story, Mr. Mosley. And I myself am intimately familiar with the dangers of whistleblowing. So that'll be a separate matter here. But what I wanted to point out for you, and I think for the rest of us, that it's not only a matter of the obstruction of free speech. It's also, it's one thing to obstruct free speech and to do it in a legitimate way, if you will, and that is to create various obstacles to the ability to speak freely. But I think it's really important to note that we're talking about free speech blocked and corruption meant to dismantle. And so, I'm really struck that there are these multiple things that are going on simultaneously, and no matter how you try to speak your truth, there are mechanisms that continue to disable you and betray you. And so I just wanted to point that out. And again, I wanted to thank you for the courage you had in coming forward.
you're welcome.
Mr. Mosley, can you elaborate? Because I think that it was your close relationships with inmates and challenging of inmate abuse. And I think also your wife, who was also a correctional officer, and made a discrimination complaint against the same facility. So give us a little bit more detail about the kind of behavior that you think made you a target.
Okay, the inmate that told me about the setup, he came to me and told me, said, Mr. Mosley, they want me to set you up and they're gonna let me out of prison. So he said, but you've been a father figure to me, something I never had in my life, and there ain't no way I can set you up. And the inmates even came and told me about a murder plot against me. Another inmate belongs to one of the, inmates protected me. If anybody bothered me, because I stood up for them. My background, I'm 71 years old. I got a history, a civil rights history that goes all the way back to the 60s. And so my original background was building submarines and warships. This was something I did later in my life. So what happened was I was an outright critic of these, what was happening. A lot of the inmates down there was like Generation X and Millenniums. And they never really readily know about the Jim Crow era and system. So what this was being implemented on them, they didn't have a clue of what's going on. And so I was outspoken about it, and I became a target, and they started spreading rumors that I was doing illegal activities. Now, if I was doing illegal activities, I'm the one initiated the FBI investigation. I requested investigation through my congressman, Gene Taylor. So that ain't nothing that somebody doing crooked would do, would be requesting an investigation. So it's a massive cover-up. Okay, people are serving time in prison now for some of the cover-up. Mississippi right now, prison system is all over the media now because it's just an integrity meltdown within the Department of Correction. These guys, okay, what you were saying?
That's a good point for us to shift to. We're going to shift to another set of circumstances. Now, first, let me see. Is there anyone in the audience? Any other questions, comments? Is there some story that you want to share? If not, we're going to move to the next feature case.
Zena,
yes.
Zena, I have a comment, if I may. And I'll try to make this brief.
You get done, Ira, then if you could unmute Mr. Crabtree, and because his case gives a really distinct, it's a really sharp contrast to Mr. Mosley's circumstances. So go ahead.
Okay, absolutely. So I'll make this quick. I'm wondering if anybody on this call knows about Nancy Schaefer. Just so you all know, and I'm connected with, I think, everybody on this call on Facebook, and yet I'm not certain that all of you know my situation. It's more family court. I have a child that was kidnapped out of the country, and I have become an advocate for family court reform and also social services like CPS. So Nancy Schaefer, if you don't know, she was a U.S. Senator from Georgia, and she was a CPS whistleblower, because CPS, Child Protective Services, it's actually Child Predator Services, and it's all a function of funding and how the money flows. And if you understand that, you get it. And she was a major whistleblower on CPS and to some extent the family court. And she ended up, according to the story, murdered by her husband, who then took his own life. And everyone and anybody who knows her personally said, there's no way that happened. They were the most amazing couple. They loved each other. They've been married for, 20, 30 years. And she was a whistleblower. And it cost her life. So,
If I could interject, and everybody, I'm not just butting in. I am the official mediator for today. But
of course, yes.
You made a good point because you're reminding me to note the contrast. There are people who are outspoken. There are people who attempt to expose corruption. They can be met with loss of careers. They can be met with, as you suggested, with regard to Georgia State Senator Nancy Schaefer, the late Nancy Schaefer. She is widely suspected that she was met with violence. Her death was triggered because of a whistleblower. We're today focusing on being set up for prosecution, whether it's criminal prosecution or disciplinary action. And the reason why that's very important is we want people to understand how easy it is to find yourself facing criminal charges or disciplinary complaints based on First Amendment activity. And the last part of all these moving parts is it can even happen when the evidence against you is totally made up. So those are the parameters of today. And so with that, we can move to Mr. Crabtree if you're ready.
Oh, can I make one?
Okay, we do have one.
Okay.
Just 1 second. Go ahead.
Okay.
So thank you, Mr. Mosley and Mr. Scott, for sharing your insight. And Mr. Mosley, your story is really interesting. I just find it interesting that you kind of had the courage to be proactive about your situation, and that you got another inmate to hold a recording device, even though it was a great risk and it could have been a great detriment to you. So, seeing as you've been involved in these situations, what tactics can people use who are being implicated for crimes that they did not commit? Like, what strategies might you recommend they do? What resources do you recommend they reach out to? How can they form coalitions together to combat unfair prosecution?
Great question. Mr. Mosley,
At
did you?
the-
Oh, yeah, well, I didn't hear him that well, but I think you said
that-
you wanted me to elaborate on what people can use. Well, every situation is unique in its own right. You know, like, even in prison, operation is unique in its own right, where they operate. And the prison, this inmate, he paid a price for doing that for me. You know, he was a nonviolent drug offender, and they wouldn't parole him. You know, they punished him, but I haven't talked with him in years. But in Mississippi, all the agencies are connected. It's a small. I didn't realize this until I got involved in this. And if the easiest thing in the world to do is set somebody up, because the inmates told me that when I got there, and I didn't believe them. They told me about the attorney general, how they set people up, plant drugs. They didn't like you in the community. They would plant drugs on you, and then make you, like I would have had to do. I would have had to plead to a lesser sentence. If they had found that drugs in my possession, if I had went to court, I would have been looking at 30 years. But they would have made me plead to 15, you know, or something like that. And you got a lot of inmates in prison in Mississippi that's innocent. And there's a great need for help in there, because these are poor people and they don't have a voice. And their life has been turned upside down. So was mine. I had to file bankruptcy twice. If you look at I've written 2 books that outline graphically what happened to me. And all of these people are high-ranking people. They were superintendents of the prison. The current superintendent there was a co-conspirator and set me up.
Okay.
And I got valid proof in those books. Zena have a book there. She can tell you it's graphic details of who these people are and their names. And I'm pleading with you people to come to Mississippi and help these people out, because their life has been ruined by fabricated evidence to enhance the prison population there for private prisons.
If I can sum up, basically you're talking about systemic problems. In other words, this is not just isolated incidents. You're not just dealing with bad luck. You're dealing with the systemic problems. And towards the end of the program, we're going to address some solutions that some nonprofit, some organizations have put in place to try to deal with these systemic problems. So hopefully we can get some go forward.
Zena, may I just make one point in response to what he just said? And I think he's, you know, hit the nail on the head accurately throughout everything he shared with us, sadly.
But I am going to got quite a few other cases to consider, so go ahead.
Okay, so I'll make this quick. I mean, as I'm listening, especially to what he just said, I can't help but go back, and Zena, you and I have talked about this one-on-one, how, you know, for me, again, very briefly, I'm more involved in the family court system, which in this country is an $80 billion a year business, and to the criminal court and what he just spoke of, the bottom line is all of this comes back to money. It's all
You're
about,
right.
you follow the money trail and you find the culprit. This is everything he just spoke about, and everything that he's been through is about one thing. It's about money.
Well,
And we can come back to that later, but yeah.
Well, yeah, because we're gonna go to Mr. Crabtree, and he's gonna give you, I think, a different, perspective, not so much to compete with anything that you said, but his experience, there's so much in common, but yet it's so different, so it gives a good sense of the wide spectrum of systemic challenges we face. So, Mr. Crabtree?
Yeah, I'm here.
Go ahead.
Okay, I'm glad to be here, everybody. After what I've been through, I'm 59 years old, and what I went through, I'm up in Montana, and actually my case pales in comparison to what I've been hearing and seeing over the last few months. But in a nutshell, my daughter played softball when she was a little girl in high school. And I became president of an ASA, that's American Softball Association affiliate here in Great Falls, Montana. And the organization was called, or is called, the Great Falls Electric City Heat Girl Softball, which I served on the board several years, and then I became president, at which time there was a gal by the name of Marley Sunchild that came on as vice president. She'd never served on the board before. And she had been making numerous unauthorized expenditures. Any expenditures were supposed to be authorized by myself as president. As a result, I was in the process of removing her from the board, and kind of to let you see what's happened, on our organization, there were numerous teams within the Great Falls Electric City Heat Girls Softball. Different age groups. Now, Marley Sunchild's daughter played for a different team, a different age group than my daughter played for. Now, her daughter's coach his name is Travis Palmer. And Travis Palmer and Marley Sunchild, the vice president, were very close friends, or are very close friends. Now, Palmer is a Great Falls City police officer. Now, when I was removing Marley Sunchild from the board, she went down to the police department with Palmer and started making a bunch of false allegations about me. Long story short, when I was trying to remove Marley Sunchild from the board, she was causing a lot of problems, and I filed civilly, and we took it to a civil hearing before a judge in May of 2016, at which time Marley Sunchild lied. She perjured herself and filed false reports or false affidavits with the court. But this detective came up and spoke on her behalf. He testified on her behalf, I should say. This created a lot of bias with this judge. Her name is Elizabeth Best. Long story short, again, fast forward in July of that same year, 2016, I was charged with theft of $2,600 in organizational funds. And what I would do, we have a facility here in Great Falls with 4 ball fields, and I would spend my own money on things such as paint, all kinds of materials, and then I would periodically cut myself a check to pay myself back. And Marley Sunchild claimed that there was about $2,600 that was unaccounted for. Now, I gave all the cash receipts to this detective, who obviously is a friend of Marley Sunchild's. They twisted everything around and made it sound like I didn't have receipts, which I did. I turned all those in to this detective. Case in point, I gave him $450 in receipts for a bunch of paint that I purchased with cash. Marley Sunchild told the detective, her friend, that she bought paint, yet she never had any receipts. There were never any reimbursements by me to her in cash or canceled checks that show that she had bought any paint. She had also testified that her father bought paint. Another time she testified that she bought the paint. But despite me giving these receipts to this detective, they claimed that I stole money. And again, like I said, this is all over $2,600. There's several other issues that I won't go into details with. Now, in the criminal trial, the detective tampered with evidence by concealment. He didn't turn in all these receipts to the court for the criminal trial, which, unbeknownst to me, I did not know he didn't do that. I represented myself at the trial. The prosecutors, they also knew that Marley Sunchild was lying. They also knew that the detective was lying, but yet they never did anything about it. So, and another issue is this judge. The judge that held the civil hearing, she went on to become the judge in my criminal trial, and by Montana law and canon of ethics, she was mandated to recuse herself, and she never did. Obviously, the civil hearing created a lot of bias in that judge toward me. So that's pretty much it in a nutshell of what happened to me.
What was the outcome of the criminal trial?
Oh, the outcome of the criminal trial, of course, I was convicted of this $2,600 because of the perjury, the tampering with the evidence and everything. I of course, appealed it, and actually my appeal decision is supposed to be finally coming down here next week, is what my attorney told me. And mind you, this is all a volunteer position. All these things I volunteered for. And
were you incarcerated? Did you have to?
Yes. After I was convicted, I went to sentencing, and I never dreamt in a million years that I would be sentenced to jail. I ended up being thrown in jail for 7 months, and then out of retaliation, because the probation office here in Great Falls and the city police officers are friends, they refused to allow me to come back to Great Falls. And their explanation or justification was because when I was sitting in jail for 7 months, I refused to acknowledge my crime. So what they did was sent me to what they call these pre-release centers in Butte, Montana, and I sat there for 10 months. So altogether, basically, I was incarcerated for 17 months, all over $2,600, which I never stole. I mean, I have all the records of it and everything. And I even sent a certified letter to the county attorney office here in Great Falls and to the chief of police demanding an investigation. I sent them a report with all the transcripts and the records proving my point, and they have done nothing about it. And that's been almost a year ago. I haven't heard anything from them.
And then, Mr. Crabtree, if you could share this 17 months that you were away, what type of important life events that you missed? I think you said your daughter. It was some important things that you missed with your daughter.
You're kind of muffled there, Zena. Were you saying how has it affected my life?
Well, during that 17 months that you were incarcerated, there were some important life events that you weren't able to be a part of, I think involving your daughter. Can you just give us a sense of that briefly?
Oh, yeah. Well, my daughter was just going to be entering her senior year of high school. My sentencing was in August of 2017, and because of this, I missed my daughter's entire senior year of high school. It ruined her softball career, basically, which she had a great passion for. I didn't even get back to Great Falls until January of this year. So and I lost my business. I'm in the contracting business, construction. So it's been very difficult. All over $2,600 and a bunch of greed and cover up. I mean, it was a total frame job and fabrication by these people completely. So.
Okay, I want to make that clear so people wouldn't think that you were just like off on some vacation for 17 months. It had real devastating effect. Okay, does anyone have any questions?
May I ask a quick question?
Mm-hmm.
I'm curious to know, you said you appealed. what are you facing potentially if you lose the appeal?
Well, if I lose the appeal, I guess then I'd have to go on to what they call post-conviction relief, I believe is what it is, and therein I can prove and show where all this corruption had occurred, where, as in the appeal, apparently here in Montana, you're kind of limited to that. I was a little appalled that my appellate attorney didn't include in there in the appeal to the Supreme Court that all this collusion and lying and perjury went on, but they say, well, that's up to a jury to decide during the trial. So that's where I'm at now. You know, I've already served the sentence, and by law, the judge was supposed to have allowed me to stay free pending my appeal, which she didn't do. So, and again, that goes back to her extreme bias against me that was created during the civil hearing when this detective testified on Marley Sunchild's behalf. So
what's very important about Mr. Crabtree's case, and I think from each case that you'll hear about today, you'll see the contrast, even though they have the basic template of having fabricated evidence in retaliation for First Amendment activity, which in Mr. Crabtree's case was just simply trying to run a volunteer softball organization in an ethical manner. But the difference, as you see, is that he was not up against some big institution like Mr. Mosley. He was up against a local private individual who apparently had a lot of influence with local law enforcement. So I just want everyone to note that. Now, what I'd like to find out if there's anyone who wants to share in the audience, if they've been in a similar circumstances, because we have a new guest who is Brian. Thank you for coming out. And anyone want to talk about having been involved in some type of activity that got you criminally prosecuted based on evidence that was false? Anyone? If not, we're going to go to the next speaker. Anyone want to share a similar case? I have any other questions or comments for Mr. Crabtree? Okay, well, if not, I want to do another sharp contrast and have Dr. Michael Langan. We're going to switch from being a criminal prosecution to having false evidence be used as part of the disciplinary action, which is a prosecution. Well, and at least for lawyers, it's considered a quasi-criminal proceeding. I don't know if that's the case for doctors, but go ahead, Dr. Langan.
Yes, the board, the medical board proceedings are all quasi-judicial, and that's one important point because quasi-judicial bodies don't need to follow the official rules of evidence. Just the what would be expected that a person would be considered important evidence. And
Dr. Langan, let me point out that your case, and as well as Mr. Crabtree, we have a written one-page description of it in our folder.
Yep. So in my case, I had shingles. I had chickenpox when I was a medical student. I was prescribed Vicodin, and I was trying to wean off of it. There was no problem or anything, but I was taking one at night, and I read about these physician health programs. Signed up, got coerced into signing up for 90 days of rehab for this at $80,000, all cash, and signing up for a 5-year contract, which towards the end of it, I was called in for a random alcohol test, which they reported positive. It was exceedingly high. I've never had an alcohol problem ever. Nobody accused me of it. And I tried to get the test results because I had been suspicious that they had fabricated it for a specific reason. I finally got them 6 months later, and it showed that the head of the physician health program, his secretary had faxed a request with an already positive test and asked that they put my unique ID number on it. And I got that, and provided it to the medical board, and they still sanctioned me. They extended it for 2 years and forced me to go to 3 AA meetings per week. Now, I took it's called the litigation packet. It follows the sample from start, from drawing the blood to testing it. And what that showed is that the laboratory, they followed his directions, put my unique ID number and a chain of custody on it. They added a collection date. And these tests, and they use them in the family court system too. They're laboratory developed tests, so they're not FDA approved. So there's no organization that can investigate suspected tampering and punish the person for it. There's only the College of American Pathologists. They can investigate and they can get it reversed, but they can't sanction the people who, even if I talked to the chief investigator. She said even if they had 10 a day, all they can do is tell the lab to do better next time. So there's no way to hold these labs accountable. Now, I had mine reversed, and what happened is they sent it back to the lab, or the lab sent it to the PHP director. And these PHPs, one of the problems is they don't allow doctors, nurses, healthcare practitioners their evaluations or their lab tests. So they forbid you to get your own records. And that's under the guise that healthcare practitioners are smart. They can figure out a way to beat the tests if they got them back, which is just a bunch of crap. So what they did, they concealed it, and then the PHP director reported me as non-compliant with these 3 AA meetings per week. Now, at this time, I had no idea that these board attorneys were in on it. I thought they were neutral, trusted them. I'd given this board attorney 10.5 months showing full compliance, letters from individuals confirming the compliance. And my attorney, he was great. I had done a lot of medical legal work, and I found out who the best attorney in the country was on this, Jacob Hafter. And he was from Nevada. He came to town, beat the hell out of these guys. I mean, we thought we won at the hearing. Turns out I'm suspended, and Hafter requests, we had no idea why, because we had given him all these records. And what this guy did, and this is a common tactic they use, there's a 7-day period when you can appeal. And it says right on there that you must do this, send it in within 7 days, specific directions. And if you don't do that, you lose your right to appeal. So what they do is they just toll the time block the appeal, and then blame it on you. So they write up a statement of reasons, and we get it back, and there's these 4 documents that they said it was based on. We had no idea what the documents specifically were because there weren't any. And then he wouldn't give us the records. I mean, multiple times, including before the Supreme Court, we requested to see these records and could never get them. So under updated public records law that went into effect January 1st, 2017, which was designed to give state agencies more accountability, because in Massachusetts, the public records department was one of the worst. Now it's one of the best. So over the course of a year, we requested these 4 documents and received them one by one. When I received the last one, I figured it out that Robert Harvey, the attorney, fabricated the entire case. What he did is and I found out this is what they do in basically every case. is they do a one-sided statement of reasons for the decision, because you have to give a statement of reasons, each issue of fact and law, for the sanction. And that requires evidence in the record, substantial evidence in the record, facts based on documents. So there was no evidence in the record supporting my suspension. So what he did is he took the attendance records from the first 6.5 months of 2012, and one of the notes from September, the fall of 2012, he concealed the latter part of the records up until October and said this letter applied to a different meeting. So it's a cheap, obvious falsification. And because you need substantial evidence, he took my rebuttal arguments, which specifically details these are not the same meetings, and said it contained an admission, that I admitted to it and that I denied ever reporting going. It's so flagrantly obvious that you can't believe it. So right then, I thought, I'm exonerated. Here's, it's false evidence by an attorney. False statements, they need to be corrected. So the attorneys at the Public Records Department, I was working with several of them.
Dr. Langen, let me interrupt you. Because I think that we've gotten a good sense of what has happened. But I want to bring out a few points that I think are going to be important for the United Nations to understand. Okay, now you talked about wanting to wean yourself off of the Vicodin.
Yeah.
So you voluntarily participated in the physician health program, is that right?
Yes, I had read about them. They sounded like a benevolent organization. I didn't know I'd be, forced into 3 months of inpatient rehab. That's
yeah, so 3-year agreement. Now this
5-year.
This $80,000, the cost of the program, did you have to pay that?
Oh yes, they're cash only, and the lab tests are cash only, and it can be up to $2,000 a month.
Okay.
Zena, may I just ask one question, because it's very specific to something? If I just
can we get some basic facts out here first, Ira?
oh, okay, yes,
Okay.
I apologize. Go ahead. Thank you.
Okay, so okay, now, so you're in the program, and you have this lab report that shows a random test that shows this high alcohol intake. And what happens is you have the lab report and you have the director of the physician health program instructing the lab to add your name and number. It's not a name, your number, your unique number and your picture to a lab report. I just want to make sure everyone understands that. It's just a lab report, and they're instructing them to add Dr. Langen's right? Now,
And a date on the original positive test, which I assume is some stock bottle or something.
in other words, anybody's name could have been added to this report.
Exactly.
As a fact, they add your information. Okay.
And I've seen multiple just like mine since that time.
Okay. Now, tell us this: what would make you a target for that type of highly, questionable conduct?
Well, it was nearing the end of the 5-year contract. I had pissed them off because I had I knew that my initial evaluation was rigged because they had done a personality test, an MMPI, which is it's objective. You fill out with a number 2 pencil.
Yeah.
Yeah, they had misreported it because I had done a study on that test for a year. I knew it was completely misreporting. And they also are altering the results of IQ tests.
Uh-huh. So you're bringing all of this out and you're criticizing this type of behavior.
Yep, and I got the neuropsychologist in trouble
Okay.
I filed a complaint with the Georgia Psychology Association,
Okay.
and actually the Georgia Psychological Board also, but they wouldn't even look at it. And they made him correct.
This is the First Amendment activity. We just want to get that point clear. Now, they eventually, you requested an investigation, and it was eventually determined that this protocol of adding your identification to a positive lab result was improper protocol. All that was thrown out, so no lab report.
Well, it's never been before a tribunal. That's the issue. They conceal it.
But the point is, the lab report is discredited. The director of the physician health program says, "Oh well, we weren't charging them with anything anyway." But now they're saying because when the lab report during the time that it wasn't discredited, they have required you to go to these AA meetings 3 times. How many a week, right?
Right.
And then, so now it's not that you had the alcohol results that's the problem. Now the problem is that you missed some meetings.
Misrepresented them. And what they did is that was not in retaliation, but to cover up.
Exactly. So,
and then they said it was a mere chain of custody error.
Okay, now this is the last point I want to make clear. So your medical license gets suspended not because of the lab reports, not because of the alcohol or drug results, because you supposedly you missed some meat.
Correct. And the records from the board, those reveal that it was concealed. They fabricated the missed meetings and then said that they discovered it afterwards and it was inconsequential.
Okay, there you
But
go.
the new records show that it was the attorney's intentional fraudulent misrepresentation that caused my suspension.
Okay.
So they successfully won in the Supreme Court by saying my suspension was because of misrepresentation.
Yes, and your medical license has been suspended since 2013, is that correct?
Correct.
And after teaching at Harvard and the like.
Yeah, and what we had hoped is that the state auditor, we've been trying to get them to investigate for the past 5 years,
Okay.
but we just found out they're not going to look at fraud.
Okay, well, we're gonna talk about that a bit going on. I just wanted to get the basic facts out there so they see the fabrication of evidence, the First Amendment activity, and the consequences on you. Oh, the last point, for purposes of disclosure, Dr. Langen and I are fellow board members. Okay, so couple of questions, Judge Nally, would you?
Well, for right now,
Okay, go ahead.
who is the gentleman?
This is Dr. Michael Langen. His written material is in there. And Mrs. Rose?
I'm sorry.
Yeah.
Is he in Georgia?
No, he's in Massachusetts. But he referenced a Georgia agency.
Oh, well, one of the evaluation facilities, one of the prominent ones is in Atlanta, the Talbot Recovery Center. They send people there.
Oh, okay.
The question I would have for you, sir, is your medical license suspended by the state of Massachusetts or the state of Georgia?
State of Massachusetts.
Okay, thank you.
Okay. Mrs. Rose?
No, I just wanted to be clear. Okay, I just wanted to be clear that what has happened is because he volunteered.
This all got started with him volunteered to go into the physician health program.
And so his license was suspended because he started in a volunteer program?
Yes, I mean, loosely speaking, but he got into a program that he eventually started to criticize.
Oh, okay.
And then that's when his name gets attached to this high alcohol lab.
And I can say, I worked in a laboratory and I can say how that can happen. Because when you are doing lab tests, you are assigned numbers. Basically, you're not given a name. Right. The only time the name is associated with lab results is at the end when the data is being input. And it's easy to fabricate in that way. And that's the truth of it. I worked in a laboratory for many years.
And see, what they did was, after the report was generated, they added his information, his identification to it.
But that's when you add, see, that's what happens though. This is what actually happens.
Okay.
When you do lab reports, you get the information of the results assigned with a number. It's only when data input into the computer that a name is associated
Well,
with
they
it.
didn't have his number. They added it, they didn't have his number. They just had the report.
They just had a
They
report.
just had a report, and they were told to add his number.
They were told to add Dr. Langdon's number.
Yeah.
They didn't know who the person was, just
They had
the
a
number.
picture of it, but they,
Oh,
yes.
well, that's really.
After the fact, they were told.
That's severely inappropriate, but I can see how, lab reports, I've actually seen lab reports be fabricated, and I didn't open my mouth. And I've seen that. Because the names are actually put in at the end during data input.
Why they fabricate lab reports?
Well, never mind. I'll ask me that question on.
So I also work in the lab. I work on Piedmont Hospital. You know.
I have seen, okay, I'll make a little statement.
Just to clarify, the person in the criticism was over the narcotics treatment?
No, just, give a quick summary of what your First Amendment criticism was, Dr. Langen, that got you all liked down at the local PhD.
Well, what I did is when I got back from the evaluation with the fabricated, what I thought was a fabricated MMPI test, I went to the head of neuropsychology at Mass General. I waited till the neuropsychologist in Georgia was on vacation, and he called under the guise that he was continuing my care and requested the original scoring sheet. So they got the original scoring sheet, ran it through the computer twice. Several neuropsychologists checked it. It was perfectly normal. There was no, it's called this L scale, the lie scale. And I found out subsequently that on mostly every doctor who goes there, they say they have an elevated lie scale, which is unusual because it's like these 15 questions where they ask you, have you ever had bad thoughts? Have you ever lied in your life? And somebody who's really unsophisticated will say, oh, no, I've never done that. Oh, no, I've never done that. Now, you know, most people who have any degree of intelligence wouldn't respond in that way. So they're giving people these elevated L scales to show that they're in denial. That's the purpose of it. Because the L scale, that indicates that you're misrepresenting yourself in a favorable light.
Okay.
So they use that to as part of the diagnosis rigging to say that you're in denial.
So you're bringing all these kind of things out and it made you a target. And we're going to get some input from Mrs. Roche, and then we're going to move on because we've got to be cognizant of the time because we're representing it. We're going to only take up so much time of our audience. So go ahead, Mrs. Roche.
I just want to answer my experience. I don't have any criminal anything that I have been associated with, but that's because I didn't open my mouth. Sometimes when tests are being run and things happen, I'll say a thing that happened when I was working in Indiana at at a hospital in the laboratory, and the doctor at the time did a knee surgery on a patient. It was a regular procedure. We did post and pre on the patient's testing. I was the one that actually reported that the post after the surgery, the post results were elevated way higher than it should be. You got to do that. That's when you're doing your test, you have to report. So I did report it. there's a procedure that you have to do. You have to call the floor, and you also have to send the results to the doctor and to different departments. I did those things. And the doctor that did this surgery was told what had happened was that the doctor had closed up the knee surgery and left gauze and some other material inside, and it became infected. The woman died. And as a result of this, I was told I had to put the statement that it was post-operative. What you have to say is that during, when you come out of surgery, and I think all the doctors, you guys doctors know this, there's a period of time where you're in recovery where anything can happen. The test that was run was prior to that time, but I was told that I had to report it as the time during that during the time when the recovery was ran.
Post-operative.
Post-operative, that's right. It's been many years, so I can't remember the terminology, but I do remember what I did, and I do remember what happened. And because of that, the person that died, the family was told that it was, you know, it happens through post-operative in recovery. And the truth of the matter is that that's not what happened. So I can see how things can happen like this, and it's unfortunate, and you know, I'm admitting some things I don't want to say, but the truth of the matter is I did that so I keep my job, and it's not appropriate. It's not an appropriate thing, but I see how people do things that are inappropriate just to say. Because I ended up losing a job when I did start doing things, because I've worked in the research until they stopped me from working in research. And at that time, I actually was blackballed out of the job, and I hadn't worked since.
Okay, so thank you for that insight. Now, at this point, let me see, we have, okay, let me take the mic. Okay, on our agenda, as of noon, we're supposed to be talking about looking at tactics that are used to facilitate the suppression of First Amendment activity. See, the point of looking at these tactics is because I think that if you're just thinking basic logic, if the evidence is false, if it's just made up, if it's fake, you know, why does it stick? How does it end up sustaining a criminal prosecution or discipline? So I'm going to, in a few moments, put up a list of the tactics that seem to help that happen. So, for example, the allegation that the evidence is false, one of the tactics is just a refusal to provide a government investigation. Okay, and that's important for people to understand, because as an attorney, if I'm, or as a private litigant, private litigant, if you were to conduct a deposition and you ask a person, if I say, Mr. Scott, you know, did you have anything to do with planting these drugs on Mr. Mosley? And Mr. Scott could just say, I don't remember, that sort of, no, I didn't, whatever. And that's just a sworn testimony, and unless I have some type of compelling contradictory evidence, I'm stuck with an answer. Whereas if I got on if I'm from the FBI, I can say things like, oh, really? Well, we've got Mr. Crabtree has told us such and such and such. You know, you can be prosecuted for lying to the federal government, blah, blah, blah. In other words, the government has certain investigative tactics and powers that it can lawfully employ to get down to the truth. So the client denying you that tool in your search for the truth can put you at a distinctive disadvantage. But of course, as Mr. Mosley's case showed, even when you have this government intervention, it can still be futile. But let me, before we go into the tactics, because because I'm gonna have everybody look at the list we've gotten together so far and see if you have any others that you want to add. I want to, for the sake of the 3 individuals who are not present either here or online, whose cases are part of our information material, I want to talk about those cases, and then the written material will be included online. Now, 2 of the cases I'm going to talk about. One I'm just going to mention, and I'll give Judge Nally an opportunity to elaborate on it because he knows the details of it much more intricately than I do. But 2 of the cases that I'm quite familiar with are the case of Maurice Morris from Toledo, Ohio, and Mark Limpton from Sevierville, Tennessee. The reason why I'm quite aware of those cases is because both Mr. Limpton and Mr. Morris are Golden Badge members. They're former U.S. law enforcement officers, and they both were whistleblowers. Now, the basic facts of their case, I'm not going to get into all the detail, but what I want you to, if you have an opportunity to look at the basic facts of the case, you'll have a sense of what the statements say. In both cases, what Mr. Lipton did was he arrested an influential businessman who was weaving and up and down the streets driving and hit a parked car, I believe. He charged him with a DUI and was told to drop the case, let the guy go, and supposedly the record of the report was eliminated from the computers. Okay, and then so that happened, but that's not the whistleblowing. What happened was Mark left that particular sheriff's office, went to another sheriff's office. After he was in another sheriff's office, figuring that the coast was clear, he reported this DUI cover-up to the Tennessee Bureau of Investigation, and then that's when the nightmare started. What happened is that a neighbor, a longtime neighbor, was a dispute over whose property it is, because this is out in the rural area of Tennessee, and accused Mark of brandishing a gun and beating him up. When it's actually, they jumped on Mark. He had his weapon with him, and you know, you talk about police brutality, he never drew it. He never wasn't even really hitting the guy. I mean, this is amazing restraint that he showed. Now, interesting, Mr. Maurice Morris in Toledo, Ohio. If there's been, just like Mr. Mosley had mentioned, all this scandal in Mississippi, there's a lot of scandal in Ohio because there's been multiple church officials who have actually been convicted and are in prison associated with child predatory sex practices in the church setting. And Mr. Morris had a personal lost a cousin to suicide because of being subjected to sexual misconduct in the church setting. So he was very vigilant in pressing the local sheriff's department to investigate these reported incidents of teenage girls, you know, the church official, the church musician having babies with them, that sort of thing. Now, but that's not really the whistleblowing. Mr. Morris, as a deputy sheriff, he would report race discrimination, but I think that the proverbial straw that broke the camel's back was he was a key witness in a local police benevolent association. He was a key witness to allegations that the sheriff improperly influenced the election, and this particular association lost the union. They lost the union representation, so that was a real big deal. And this sheriff did end up going. He got charged with the crime. I think that he was acquitted, but he was a controversial figure, and Maurice provided key evidence to suggest that this sheriff did improperly manipulate the evidence. And then I think less than 60 days later, or let me see, Yeah, yeah, less than 60 days later. Mr. Morris was part of trying to arrest, he was off duty, he was trying to arrest a church pianist who had been charged with impregnating a teenage parishioner. And they accused Mr. Morris of assaulting the guy, hitting the guy during the course of the arrest. The child sexual predator is not certainly the most sympathetic criminal, but what happened is that the church community didn't appreciate the scandal that Morris was bringing to them. And they just basically painted him as a vigilante. And in other words, what was fabricated is the notion that he hit this guy during the course of the arrest. Now, those are the basic facts, but what I wanted to emphasize is the decision to prosecute Mark Lipton for assault and battery against his neighbor, and the decision to prosecute Maurice Morris for assault, for battery against this alleged church pedophile. And they also accused Maurice of perjury before the grand jury. The decision to go ahead and prosecute them, you've got these questionable private citizens accusing law enforcement officers who had stellar records of misconduct, and the law enforcement officers got prosecuted and convicted and lost their career. And, it suffered a tremendous family devastation. Mr. Lipton had 5 or 6 children and a wife to support. He lost his job. Now, put in the backdrop of that, all the outrage that we've been experiencing over the last few years about police accountability. We can't get people prosecuted when they're shooting you in the back 7 times on video. But yet still, a law enforcement whistleblower gets prosecuted and convicted and sentenced, Martin Lipton, his 5-year prison sentence was suspended. I think that's the word, suspended. Maurice Morris actually spent some time in jail. They went to jail for supposedly assaulting or hitting private civilians. Both of them have checkered background. The gentleman that Mr. Lipton supposedly hit, brandished his gun in front of, had a remote history of, threatening his wife to kill his wife, threatening suicide. His wife, his daughter, had during the time of trial, was on probation or something for drug dealing. And I'm not saying that if you don't have a pristine background, your testimony against a law enforcement officer shouldn't be believed. That's not what I'm saying at all. But when you can see how difficult it is to get a law enforcement officer prosecuted in the face of troubling videograph evidence, to think that prosecutors would choose 2 law enforcement officers who had a stellar record and present to a jury this theory that somehow they had turned overnight, after years on the force, into these belligerent law-breaking threats to their community, it's a bit far-fetched. So that's what I'll say about that, and recommend that everyone look more closely at their 1-page statement if you want more details as to how they were set up to suppress. Both of them were whistleblowers, and both of them had, they contend, evidence of criminal conduct on their part made up, fabricated. Now, the last report is a very interesting story that I'm going to have Judge Nally talk about a bit later when he comes up to give his presentation. It's that of Amy Barmucci, and that's a very, very troubling story where this young lady, found 9 law enforcement officers who had entered her house supposedly on a wellness check. She told them to leave, and she went upstairs. They, out of fear that they were going to forcibly remove her, that she went upstairs to her bedroom. She did secure, I believe it was an unloaded weapon, and that may say, oh, well, you know, you resist, and oh, she has a weapon, they can shoot you down. But Judge Allen can talk with you about the fact that we, at least here in Georgia, we do have a right to defend ourselves against even law enforcement officers under certain circumstances. She had an unloaded gun, and this wellness check turned into her having 345 caliber bullets shot into her body. And she miraculously recovered, but to sort of cover up this thing that was all on tape, with her telling them 10 times at least to leave her house. So the reward for all of this is she gets criminally prosecuted. So he'll talk a bit about that, because it's important to understand that she was well within her rights, but she was portrayed, they made up this scenario that suggests that she was in fact a criminal. Okay, now what I'm going to do now is I'm going to have to screen share to pull up this list of tactics so that we can talk about that. So let me do that. I don't think my co-host can do that. Let me do that. Okay. Here we go. Okay, now, hopefully everyone can see this. And I'm just going to sit here to talk about how you have fake evidence. Let's see if I can control the view. Okay, there you go. Okay, hopefully everybody can see. Now, you got this fake evidence, so how does this stick? How do you end up going to jail if the evidence is fake? How do you end up losing, getting disciplined, getting removed either temporarily or permanently from your profession based on fake evidence? Well, one of the things that we talked about is they declined a government investigation of the circumstances. Another thing that we came up with is they failed to inquire of one or more key witnesses. Like Mr. Mosley said, they had his book indicates they had a hefty investigation report, but not a single person who knew anything got interviewed. So it seems. Then there's also a disregard of flawed logic and our statistical impossibilities. That calls to mind for me, Mr. Lifton and Mr. Morris's case, where you had people in a matter of months going from having these stellar records as law enforcement officers to supposedly beating up people, private citizens, and lying about it, after their whistleblowing was a part of exposing misconduct. And particularly like Mr. Morris, he's complaining about violations of civil rights against him. But now all of a sudden he's beating up people. It's a implausible prosecution theory. But you have the court, you have the prosecutor, you have the juries going for it. That's another way that this false evidence sticks. Then I think Mr. Mosley talked about that. Then there's a disregard of objective exculpatory evidence. You heard Dr. Langan talk about, he submitted his information. It never makes it to the fact finder, or it's just ignored, it's just poo-pooed. Then you heard Mr. Mosley made it to trial. He talked about key witnesses, the jury being escorted out of the courtroom when key witnesses are testifying in his behalf, and other prejudicial trial error. The hypothecation of facts, that's a 75-cent word that I actually, hypothecation that I actually found in case law. And it's hard to describe what that means, but it's when a court makes a decision And it's like, they pretty much like made up the facts. The facts of the decision, if those were the actual facts of the case, it would be a good, a sound, defensible judicial ruling. But the facts of the case have little relationship to what you actually presented to the court. So that happens. It can cover up false evidence. And the bad thing about hypothecation of facts, and I personally in this situation, even though I didn't get set up for criminal activity, but what happens is you have these decisions that are reported against you, and if you Google my name and look at these judicial rulings, the outcome seems appropriate based on the facts that are presented, but those facts have very little to do with what was actually presented to the court. Then you have the investigators and or the adjudicators that have conflict of interest. And I think Mr. Mosley talked about that. And I think Dr. Langan talked about that. And actually Mr. Crabtree pointed that out with regard to Judge Best. Then another thing that happens in court, you have these abrupt departures from precedent. I'm not sure if I heard a lot of that through the cases that we consider today, but I know from I know from my advocacy and personal experience that you can research and go into court in light of current law and believe that you are entitled to prevail, and all of a sudden the case law doesn't mean anything, and there's an abrupt departure from it in order to rule against you. And then finally, there's a clear misapplication of law, and that's another way that this false evidence can end up sticking. So does anyone, I'm gonna pause sharing, no, I'll keep it on there, and then what I'll do is show the video panel and ask, does anyone have any other tactics that in their view allows this to happen where the false evidence sticks? And what I'll do is, if you have some ideas, just shout them out. I'll write them down, whether you're here in the audience or not, and live or by video or audio, and we'll include that in our report to the United Nations. So you're not obliged to come up with any other tactics, but does anyone else have any ideas or tactics that are used to thwart really the pursuit of truth?
Judicial and prosecutorial misconduct.
Okay.
In the abuse and subversion of otherwise proper rules of practice and procedure.
As a mouthful.
Yeah, but it was succinct.
And that's judicial and prosecutorial.
Prosecutorial misconduct in the abuse and subversion of otherwise proper rules of practice and procedure. We've got 3 cases like that right now here in Georgia. One doesn't take care. Y'all ain't from Gwinnett, are you?
We are from Dunwoody. Very close.
Any other tactics anyone wants to add?
Yes,
Okay.
I have this.
I would like to add something.
Just a second, Mr. Mosley.
Coercion.
Okay.
Just a second, Mr. Mosley. But Mr. Mosley, hold on for a minute. We got someone here live. Go ahead.
Okay.
Just hold on for a second. What do you say have?
Coercion versus the worldwide rule of judges.
Okay, this is Robert Bork.
I know, that's what I'm saying.
Coercion
This
versus,
happens
yes.
every day. Because I'm going through a case right now, that's why I came here.
Okay. And anything else?
Well, not.
I'm gonna write that down. What, and do you want to elaborate on what happens and what it is that you're going through?
A law case, that's a lie, like you're talking about now. It's a lie that they both told, both parties, and they want me to sign a document, and I wanted someone to see this lie. You know, that's why I came here. And then also because when it came on my web, the information Amora, that's how I found out about this.
Okay, what I'm gonna do is I'm gonna take this off the screen and you can come up here and tell us about it if you like. Do you want to? Or you rather not?
I'd rather not.
Okay, go ahead. You can,
But I want to ask one other question.
okay, go ahead.
It's also on the website, when they sent the information to my website. It also spoke about disability law.
Yeah.
And so that's really why I came.
Well, we might have misled you there because we're glad you came though. But disability law, that our organization deals with judicial and disability. We're not disability like people who are physically disabled. We're talking about judges who, because of physical disability, they can't do their job right. Because sometimes you have judges who actually are, they have dementia, they may have some form of mental problem, and you can detect that, and they're issuing rulings. So that's a part of judicial conduct that we monitor. It's not always just about someone conspiring. Sometimes it's they're not able.
So I even wrote the Supreme Court for help, because, like I said, the lawyers that presented my case, they lied, and the person where I got hurt at, they lied too. And that's why I wrote the Supreme Court, because I read in my book that I have, it's called the Constitution, that the Supreme Court is higher than the local law, so that's why I wrote them, and I just haven't heard anything back from them.
Okay. Well, Mr. Mosley, we're about ready to go to our next part of our meeting. What was your comment?
My comment is about the way investigations are conducted in Mississippi. When you say the Justice Department, but you actually have resident Justice Department people. That a lot of them was already in the law enforcement. Then they moved up to the FBI. So when you got an investigation, they should be people that come from another state instead of the resident investigators. Because as in my case, my case was a civil case. And, in civil cases, you got to reach the preponderance of evidence. I exceeded that bar. And still, a judge didn't give me a favorable ruling. He suppressed the evidence. And during the process, the judge suborned perjury, because he had heard that tape before before the court. And he let that guy on the tape get up and testify when the jury wasn't there, and the guy committed perjury, and he knew he was committing the perjury.
Well, let's move now to the solutions phase. And again, this is a community consultation. We're not here to lecture for hours on end about advocacy strategy. But I thought it was only appropriate that we spend some time here to make everyone aware of the type of strategies that organizations and advocates are pursuing to deal with these systemic problems that systemic with a big S and a little s. Mr. Crabtree was dealing with a systemic problem, but it was limited to just a relatively few influential individuals. So hopefully you all see the full scope of this societal problem, where our criminal justice system and our professional disciplinary agencies can become tools of suppression. Now, I'm listed as the first to speak. I'm tired of talking. So I'm gonna let Judge Nally start, and then we'll go to Dr. Mannion, and then I do want to tell you all about a few things that our organization is doing towards this. So at this point, let me introduce you Judge Paul Nally here from Georgia. He is our he's resident expert of grand jury access. Thank you so much, Dr.
Thank you, ma'am, and it's good to be here with you folks today. Can you gentlemen hear me okay?
Yes.
Okay.
Yes.
Now, don't hesitate to interrupt. If I talk too low so that you can't hear. But let me start off by saying that in our Constitution, the most powerful, and I mean without exception, the most powerful tool is the First Amendment, right to petition, right to peaceably assemble, right to speak to, and the right to be heard by those, in the language of the Georgia Constitution, vested with the power of government for a redress of grievance. That is the most powerful tool in our tool pouch for managing our government. Now, why would I say managing our government? Because for all of the glorious verbiage cast upon our Constitution, it is nothing more nor less than a written special contract.
Yep.
The reason I call it special is because it is one of the types of contracts where not everybody has to have the mens rea, the consciousness of mind to understand the terms. They're your rights, and they are the duties of the government, whether you understand them or not. Well, guess what? In that contract, in both of those contracts, God Almighty saw to it that the day you were born, and I'm talking to each one of you, you lived your life until you were able to reach the age of 18. And on that day, you walked up to a table, you pulled out a chair, and you sat down at the board of directors of two of the largest corporations in the world, the United States of America and the state of Georgia. You are board of directors members, unless you're working for the government. Now you're a public servant. You are the constitutional superiors of your constitutional inferiors. But even we who sit at the board of directors have decided in the state of Georgia, now I can't talk about Mississippi, Maryland, Illinois, well, I can talk about Illinois and Texas. Folks from Illinois, you have my deepest sympathy. Texas, you folks are okay, you're in pretty good shape. Kansas also. But in the state of Georgia, we even answer to our grand jury. Because the reason we do is because our grand jury is a child of the common law. It is not a child of the state legislature. The Georgia legislature cannot make one law about the grand jury or concerning the grand jury except for how they're selected and how they're paid. That's it. They cannot touch a grand jury with a statute any other way. Now here's something that every one of you gentlemen up there on that monitor need to understand, and everyone whose names appear here in this list. Every one of you who have been punished for the exercise of your First Amendment right, you need to understand that you are the victim of federal criminal acts. You are the victim of an operation of 18 U.S.C. 241 and an operation of 18 U.S.C. 242. And if convicted, that's 6 years in the federal pen. Not only that, but if you sue successfully and get a judgment, how many here know what the value of one civil right is? How many of you know? How many of you know that Congress even put a value on it? One of your civil rights. What is it worth? Well, your right to responsibly exercise speech. According to the United States Congress, in 18 U.S.C. 3572, if your right is violated by one individual, it's worth $250,000. And if a corporation violates your civil rights, that jumps up to $500,000. One violation. Just one violation. You need to understand the relationship between civil acts, what appear to be civil acts of retribution, and the criminal code. Here in Georgia, if what had happened to you gentlemen because of your whistleblowing or because of your otherwise use of your First Amendment right, not only would there be a violation of 2 federal statutes, there is a violation of Georgia's theft by taking statute. That's another felony. That's 5 years. A question? Did somebody have to say something?
Just clear the throat.
Okay. Now, we have a problem in this state.
Yes.
Dr. King didn't get done. And the reason he didn't get done was because even though he brought the voices of the abused and oppressed in our society, black and white, by the way, and he put it out on the street, but he did not get to the courthouse with it. Because with the power of a Georgia grand jury and the evidence and testimony of one citizen, a grand jury can clean out an entire county. It can clean out the entire state of Georgia. Why? Because our Constitution goes further than establishing a grand jury. It says over here in Article 6 that they can stick their nose in any judge's business in this state. That includes the Supreme Court of the state of Georgia, folks. They can stick their nose in the governor's business, and there ain't a thing he can do about it. And has this ever happened? Yes, it did. There's case law. A grand jury down in Liberty County back in 1953 decided they didn't like the way their sheriff was handling the liquor laws. And the people were getting upset about it, and they were talking among themselves. Finally, 3 men got together and said, we're going to put a stop to this. And they go see a local attorney. And they tell that attorney, we want to hire you to take our complaint to the grand jury. Sure, let's go. He goes to the grand jury, and lo and behold, the grand jury says, yeah, y'all come on in. That's your right. Bring us your information. When they got through testifying, that grand jury was so incensed that they were ready to indict that sheriff. And then somebody said, wait a minute. Now, we don't like what the sheriff's been doing, but we got a problem. If we indict him, he goes to trial. Now, if our neighbors on the trial jury get as ticked off as we are, well, they're liable to find him guilty. And if they do, the judge is going to have to send him to a federal pen. A state penitentiary, or a chain gang back then. Well, what they knew was any law enforcement officer, especially a sheriff, getting convicted and sentenced to a state penitentiary, that was a death sentence because his life expectancy was about 30 days. And they didn't want him killed. They didn't like what he had done, but they didn't want him to be put to death. Well, what else can we do? Oh, hey, we can order the governor to remove him. Yep, they can. They could. And that's exactly what they did. They sent a special presentment to the judge, for the judge to send to the governor, you will remove our sheriff or cause. Well, now at the time, the governor happened to be Herman Talmadge. And I don't think there's anybody here old enough to remember the Talmadge dynasty, Herman and his daddy Gene. But them boys bored with a big office, let me tell you. whatever they said in the state of Georgia, it went. Except when it came to a grand jury. A sheriff was known throughout the state to be the finger of the governor in the pie of the puppet. And Herman Talmadge wasn't happy with the idea of having to get rid of one of his good old boys. But not even Herman Talmadge was going to say no to a grand jury. That is the kind of power a grand jury has. They tell the government what they're going to do in the interim time between you're going to the polls to vote here and you going to the polls to vote here 2 years later. In between, it's your grand jury that helps each one of us manage our government on a day-to-day basis. So, gentlemen, I would urge you to consider carefully the criminal laws in the state in which you were abused and to determine whether or not your grand jury is independent enough to hear your evidence. Here in Georgia, every one of you could be heard by a grand jury. Texas can be heard by a grand jury with the consent of the district attorney. In the state of Kansas, you have an absolute right to petition directly the grand jury, either in person with, when I say in person, I mean a letter or a phone call or a handshake on the side of the road with a grand jury member, or you can send a request through the district attorney in Kansas. Now, I'm sorry, I can't talk to any other state.
I have a question, if I may. Broadly speaking, I guess a couple of points. One is to everything that you just spoke of, as well as everything we've heard prior to your speaking from the other people on this call and in this meeting. One, I would ask, how do we utilize Section 242, Title 18, deprivation of rights under color of law, and also Section 4, misprision of a felony, and specific to the broader topic here, the First Amendment, how do we go about violation of our First Amendment rights when courts impose gag orders on us and silence us? And the last point to that would be courts being able to video and audio tape everything, and we as litigants are prohibited from doing so.
First off, when you have a problem the magnitude of what you gentlemen have, I think all of you already know, and all of you should understand, first thing you need to do is find you a good attorney. Now, I've got one rule of thumb that I can use for getting an attorney, and that is when you go in, the very first question out of your mouth is, can a judge commit a criminal act from the bench? And you'd be surprised how many attorneys' eyes will bug out. What? What kind of stupid question is no? If they don't know, or if they say no, you need to turn around and get out of that law office. That ain't a lawyer. That's a mouthpiece for a criminally organized society. But assuming they say, yeah, it can happen, then you want to know, well, what's the remedy? Well, criminal prosecution. Well, how do you criminally prosecute in Georgia? Well, you can do that several ways. You can go to the police department. You can go to the investigators, city or county. You can file a criminal complaint with a judge for a warrant. You can let the district attorney know, and he in turn will go right back to the investigator and give them the information, and they'll pick it up from there, and then they'll return a report to him. What's the last thing you can do? What do you have a constitutional right in this state to do? In the language of Henry Lester, 77 Georgia, Page 143 is where it starts, but flip over to page 148, and there you will find the words of Justice Hall, who in 1886 said, "Every citizen or person of lawful age may come forward and prosecute for offenses against the state." And if he does not wish to prosecute the matter, he may give information thereof to the grand jury or any member thereof, whose duty it becomes to inform his colleagues, and in their duty to diligently inquire and true presentment make. When you go before a grand jury to complain about criminal misconduct, you are standing with your feet in the place of the state's prosecutor. The district attorney needs to just go sit down in his office and get him a donut and drink him some coffee, and the grand jury will call him when they get ready. Another thing, whatever business you have with a grand jury is secret. And you were talking about 18 U.S.C. 4. That is a federal commandment. If we're talking about a violation of your First Amendment right, you have a duty. You have a statutorily enforceable duty to go tell somebody. It might be the sheriff, it might be an investigator, it might be a district attorney, or it might be a grand jury, but you have a duty to report violations of federal laws and violations of your civil rights, by the way, are violations of federal law. One thing I would like to leave you with, and that is, if any of you are ever sworn as grand jurors, do not ever allow any citizen to be turned away until you have heard, hear their voice. I don't mean send you a written note. They can send you a written note, and that's fine. But you want to hear with your ear, see with your eyes their complaint. Don't ever turn them away, because if you do, then you become the worst traitor to the liberty guaranteed in our Constitution. Thank you, ma'am.
Okay, Dr. Mannion is going to give us a real eye-opener with regard to the plight of much too many physicians in the United States of America, representing the Center for Physicians' Rights. Dr. Kernan Mannion.
Great. Thank you. Can you hear me okay?
Yes.
All right, great. Thanks so much, Zena. I appreciate the opportunity to speak very briefly here. I got involved, I know Michael, and I got involved with regard to this abuse of rights of physicians via these devious means as a result of my own experience as well. I blew the whistle on a corrupt, deficient system of care of Marines coming back from Iraq and Afghanistan with PTSD, post-traumatic stress disorder, and authorities didn't want to hear that, and so eventually it escalated to the point of them coming after my career. So I understand how these mechanisms work, and I wanted to just make just a couple of general comments here, because I know we're very limited on time, but I wanted to capture some of the things that I heard in the meeting today. And again, I want to applaud those who continue to fight against a system that is inherently defective, if not corrupt. And I wanted to kind of offer some overarching ideas here. That when we think about this notion of freedom of assembly, freedom of speech, it's one thing to be speaking about the guarantees that we have and the appearance of justice, the appearance of that freedom. You see, and so I think part of the thing that is very important to report to the United Nations is just because someone has all of these guarantees written out doesn't necessarily mean that you're going to get them. And so what we have here is a system of appearance, the apparition of justice. And so I want to address then that when we think about systems that are broken, okay, we think about, we got about, let's say, for example, if we're talking about a school system that's broken. Okay, imagine this for a moment. We've got a school system that's broken, and we got people who are saying, so what happened here? You tell us that you got these high scores, but you really don't have these high scores. So one level of badness is that they lied about the scores. Okay, they basically said, no, well, you know, we covered it up. The second thing is that they actually planted bad scores, good scores, and tried to deceive the authorities. The third is kind of like, imagine this, where you've got a system that's trying to pose itself as good, and yet it doesn't just have bad scores, it's actually harming its students, it's whipping them, it's punishing them, it's abusing them. So we got these levels of problem in a system. Now we got to be thinking about the system and its brokenness and the harms to people, and how do we address that? So when we think about remedies to a broken system, we got to be thinking about remedies to fix the system and remedies to help those who are harmed, the victims. All right, so I just want to be thinking overarching here about that big picture here. So that when we think about systems and we think about broken systems, let's say, for example, a corrupt process where somebody tries to speak their truth, and not only is their truth not heard, but their truth is destroyed. They are discredited. But then not only that, we have the conspiracy of forces within a system that comes in to actively harm them, to shut them up, to punish them for speaking the truth. So what we're looking at here is we're not just looking at deficiencies of constitutional rights. We're looking at flawed systems, and we're not looking at flawed systems that are just kind of like naturally flawed, because we all have imperfections. We build a system and it doesn't work the way it's supposed to. But we have systems that have flaws to them. The people who were supposed to correct those flaws are remaining silent. The people who are overseeing them are allowing that to get passed. And the people who are the overseers outside of the system, like, for example, the Inspector General, the Office of Inspector General, is then part of the problem where it suppresses. And then we have part of a system that actually punishes those who try to fix the system. So what we have is gradations of wrongdoing of a system. And with the gradations of wrongdoing of a system, it becomes more difficult to fix at an individual level. You have to have kind of a systemic approach. And so consequently, that's what the Center for Physician Rights is doing. So with regard to the problem of physicians, whistleblower physicians in a hospital can get their careers ruined by simply bad talk and contrived evidence, and then they go to court and they're bankrupted. And they keep going higher and higher in court, and they get bankrupted, and ultimately they are out of money, they're out of their jobs, and their lives are ruined. And this is a common plight, by the way, with regard to whistleblowers. So I just want to overarch, just kind of give that overarching perspective on solutions. So with regard to the last thing I want to say here is about, with regard to the solution for physicians who are having their laboratory results fiddled with, their psychological tests fiddled with, they're being hospitalized against their will. Believe it or not, in this country, physicians are being hospitalized against their will. The kind of thing that was done in Soviet Russia, right? And because you blew the whistle, you were labeled to be a pain in the butt. And then because you were a pain in the butt, then you got your career derailed. And it gets worse and worse and worse. And physicians are now in these systems committing suicide because they can't get access to justice. Now, this is what's called, in the world of psychology, is called not just post-traumatic stress disorder, this is called moral injury. When a system betrays you, it betrays your fundamental belief in the rightness of a system. You suffer what's called moral injury, and moral injury is profound because you're saying, I can't get justice, all right? And so the people that we've heard speaking today are saying, I can't get justice, I feel deprived of justice. And not only do I feel deprived of justice, I feel like the system itself is broken, and I try to call attention to it, and I get harmed again. So it's a level of severity of a problem that we must address at a systemic level. So going back to the physician thing, there are several strategies that we developed. And we're in the process of executing. One of which is, of course, is educating everyone. letting them know, people, you're going to have to take an active role in fixing this. Don't sit back on your butts and just say, oh, it didn't affect me, so I don't have to do anything about it. It does affect you because the system is broken, and it's going to get to you if you don't. The second thing is that we're working on is, imagine this. So a physician's being brought into this system, this broken system, and it's a rigged deal. You know, I've heard multiple people say there are multiple agencies involved. There's a confluence, there's a conspiracy of agencies all together. So therefore, one of the ideas that we're working on is to have an independent oversight entity. We're going to call it an ombudsman. And that ombudsman is going to be legally trained. And every physician who is brought before these very powerful and corrupt regulatory bodies, the ombudsman, independent ombudsman, preferably a lawyer, is going to be hired independently and is going to basically serve as a guide through the system. And is also going to demand that people be called attention to that brokenness and corruption be called attention to, and says, no, I'm sorry, we're going to halt the process right now until we get this part of this procedure and this violation corrected. Okay, so that's one of the biggest processes that we have. And I think that again, what we need to be thinking about when we think about systems is the system itself. What do we do when we have failure of the system, failure of the leadership, failure of the internal controls to fix it, failure of the external controls that are meant to correct its wrongdoing? What do? We have to address that part of it. And we also separately have to address the harms being done to individuals who are hurt by defective systems. That's what I have to say. I hope that gives an adequate overview.
Excellent.
That was a great message.
Thank you.
It was.
Yeah, outstanding. Thank you.
Especially your attestation to the need to address these situations as specific. In answer to the question about how widespread is it, and each of these individual fact patterns, it has a constituency. It has people who are caught up in similarly situated dynamics. Okay. Now, our organization looks at the legal system holistically. So whether it's a criminal court, family court, we're looking at the extent to which the legal system, not just the courts, but every branch of government adequately protects the rights of individual rights of average Americans. And our projection has been that there has been as little as thousands and as much as 1 million or so average Americans who are subjected to persistent U.S. legal system abuse. Now, in a country that has how many population?
300 million.
300 million, even if it was 1 million, if it was 2 million, if it was 3 million, that's still a relatively small population. So it's important to understand that these problems are intergenerational, okay? Because the children of the people who are, that we've heard experiencing these problems directly, it's impacting them. And Mr. Scott is our resident expert on what's called adverse child experience. And it literally, you're talking about not the people who are directly experiencing this literal persecution and psychological torture through persistent abuse of their rights. They're having a limited life expectancy. We've heard projections as much as 20 years is shaved off your life because of these type of difficulties. And guess what? The same thing with regard to your children. Even though they don't have necessarily the direct legal system exposure, they are traumatized by the parents in conflict, divorce, financial instability. I don't get to go to college. I don't get to go to college I intended. They're drinking. They're promiscuous. And it's an ongoing cycle. They produce children, and then their children, the drinking, the drugs, trying to get attention. And each generation ends up with, and we've had projections as much as 20 years of their longevity eliminated. So if you start looking at how it compounds itself, then that's when the numbers are staggering. Whether you want to say it's 300,000 people who are directly affected or 2 million, the point is their children are affected. I don't have children, but I have nieces and nephews that I don't have relationships with because I've been off at war. for couple of
That's
decades.
exactly where you think.
Exactly. Okay, now, affect me. If we were to announce that we were gonna have a case intake today, and we got three lawyers, and, they're gonna be taking your case, and everything's gonna be free, and we're gonna get you media attention, all that kind of stuff. We couldn't, we probably get some type of, city code, violation notice, because of the crowds of people who would be taking us up on that offer. Because we've got people who are so focused in on their specific circumstances and the offense, imposed on them. Well, when we are here and we have this group assembled, if anyone was here, if we had large numbers of us, then they will get to see how, because of systemic problems, I mean, we've all had the lawyers, we've all done the pro se advocacy, we've gone through the investigators, we've done it all. And we see the ineffectiveness of that process. Because guess what? To get individual relief, we've got to treat the problems of what it is about these systems that fail to provide reasonable redress and the relief to which we are entitled to. The next thing is with regard to prosecution priorities. Our organization is focused in on that. We are publishing an online publication called Priority. And we're showing through our Facebook page how we're in a country that incarcerates more people than any other country in the world, but they're quite astute at sheltering their court officers from investigation or prosecution. I don't care how compelling your evidence is of lawyers and judges conspiring to violate those criminal codes that Judge Dowley mentioned, are worse. Now I shouldn't say are worse, can't get much worse. I mean, those are just two of the federal provisions that can be cited. Mr. Scott mentioned misprision of felon. It's a variety of offenses. And no matter how compelling your evidence is, wouldn't be surprising if you don't even get an acknowledgement of your phone call or an acknowledgement of your letter. So it's about prosecution priorities. In Illinois, I'm always using an example. This homeless man stole underwear from a Dollar Tree or something like that. He went to prison for 10 years. But Mr. Mosley couldn't even get the 20 or so key people in a video, audio tape exposed conspiracy to plant drugs on him in a correctional institution. He couldn't even get those people interviewed. But we sent this guy to prison for 10 years. That's the priorities of prosecution and the priorities in this country. But what I'm getting to is we, the people, have to play our role in impressing upon our executive branch leaders, our governors, our president, how we want our resources used. What cases do we want investigated? What cases do we want prosecuted? We do not have to just accept how it's done. And the local prosecutor, most of them stand for re-election. Governors get elected, presidents get elected, and if they are not instructing the Department of Justice, the U.S. Attorney General, or their state prosecutors, or if they're not directing, because the prosecutors are part of the executive branch, and if the prosecutors are deciding to go and make sure that we sleep safer at night, knowing that Bart Crabtree is in jail for stealing $2,500. If that's what they just think is the way, our resources should be expended, guess what? We don't have to agree with them. And if enough of us, said this is not acceptable, and if you don't change it, guess what? You won't be working for us much longer. That's how it goes. Now, a practical point, one of the things I found is I see a lot of cases where people want help. But I am an officer of the court, even though they don't seem to like me very much in the court setting. But I do have ethical obligations, believe it or not. And one thing I see is that people, they present so much detail that I want to help them, but I have an obligation to have independent knowledge of a lot of things. And when you start making all types of accusations, I could have some problems if I click like, if I promote this. So what I'm getting to is keep it simple. Just identify a few basic points that's a problem. And then I think you would find people more willing to rally behind you. Don't try to tell them every little nuance of everything that happened to you. Get to the basics. I've got an audio tape where they are admitting to planting these drugs on me. You know, the ones where you hear that, and then you can say, hey, this is wrong. But when he goes in and, you know, when someone goes in and starts giving all kinds of details and, you know, this motive and alleging this and stuff that none of us can have direct knowledge of, you make it more difficult for us to rally behind you, because now we got to quit our jobs and hire private investigators and read reports just to know whether, you know, it's a sound case. Most people don't want to get caught up in some type of frivolous action. Finally, human rights advocacy. Our organization has taken a position that the ineffectiveness, the fact that we've spent the last 2 decades chasing our tails, going from one motion after another, one request after another, one investigator after another, one prosecutor, one legislator, blah, 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 no money. We're saying that this reflects ineffective avenues of redress in the United States. When you are alleging that the government, and particularly court officers, are responsible for this persistent, deliberate, allegedly deliberate violation of your rights. When that's your claim, the system, it just becomes a shell game. And you spend, you know, some people don't even live long enough to get through all of the maze just to end up with boilerplate letters and ridiculous, you know, explanations like the response that Dr. Langen got. Once his lab report was discredited, oh, well, we weren't using that anyway. But, you know, he's done something, he missed these meetings. He wouldn't have been ordered to go to the meetings if it wasn't for the fraudulent lab report. The meeting request requirement was a result of the fraudulent lab report. Now he loses his license.
And Zena, I'm trying a new tactic on this. The board attorneys, now, they found out about the reports being fabricated by the attorney at the board a year and a half ago. And what they did is told the public records attorneys, you had no right looking at those and you have no authority to report it.
And you know, and you mentioned that's how they got around.
Yeah.
They quieted the records attorney and also another attorney, right?
Right, but what they're doing is basically turning a blind eye to it, ignoring it. And you know, as attorneys, they're obligated to correct false evidence. And here it's 100% false.
Now we're gonna have to end for the day our recording. But what I'm saying to you is, yes, we're in this country, you know, we have to try to protect and preserve our rights. But our contention, our organization, we have a campaign called Option USA. And we're contending that's not due process. That's not an effective avenue of redress. The fact that we got one more thing that we can file is no indication that this is an effective avenue of redress. We're not having our rights adequately protected. So we need people to be aware of this campaign and be supportive of it. Believe it or not, people are, you know, resisting this campaign, even though we've got the United Nations Human Rights Council who has said that these allegations that the United States does not provide effective avenues of redress seem to be well taken. It's not a manifestly ill-founded allegation. That's phenomenal. It should be ridiculous. It should be ridiculous to allege in the United States of America the judges are facilitating the persistent violation, the literal persecution of average Americans and psychological torture. That should be ridiculous. Instead, the Human Rights Council can't come back and say that allegation is not manifestly ill-founded. So again, if people understand that the nature of that these are systemic problems, they would not so much. Yes, you got to get a lawyer. You got to file your motion if you're advocating pro se. But you also have to understand that trying to pull relief from a system that is geared to deny you relief is the definition of it. Is the exercise of futility, and close to that other guy that said something was insane. Okay, now we have to end. We have to stop the recording because we want to respect people's time. But I want to encourage everyone here to go downstairs for a minute before you leave, and visit our gallery where you'll see some beautiful works of art that were prepared by people who have been incarcerated, largely wrongfully convicted.